Thank you very much. I normally teach appellate issues in federal sentencing law, but in thinking about this presentation, I realized that you may find that equally as boring as I find it interesting. So what I wanted to do is kind of paint with a broader brush and talk about something I think may be applicable to anyone who does legal writing, even if it's just at the pretrial level or trial motions all the way up through Supreme Court practice. So the title of my presentation is How to Tell a Story and Why. And I kind of wanted to start in an unusual place. I wanted to start in a case before the U.S. Supreme Court. It was actually before them in 2003, and they decided it in 2004. A case called Alaska Department of Environmental Conservation versus EPA. And I've listed the issue here, and you can see it's an administrative law issue, and it also deals with aspects of federalism. Now, fairly opaque if you don't practice administrative law. But what I wanted to do is read an excerpt from both the petitioner brief and the respondent brief, and I think you'll see where I'm going with this. So I want to start with a short excerpt from the facts section of the respondent brief. So this is the brief for the Environmental Protection Agency. I'm going to read two short paragraphs. Teck Cominco Alaska Incorporated operates the Red Dog Mine in northwest Alaska, which is the largest producer of zinc concentrates in the world. Many workers are housed within its boundaries, and native Alaskans reside in the nearby villages. Cominco first obtained a PSD permit from petitioner for the mine in 1988. The mine produces its own electricity. In order to ensure that emissions of nitrogen oxides from its power generators remained within permissible limits, that permit, as later amended, included restrictions that limited the operations of the mine's 5 original diesel-fired power generators. In 1996, Cominco initiated an expansion project to increase zinc production by 40%. The state of Alaska provided just under half of the funding. The project was to increase the mine's workforce from 406 to 476. Because the expansion would significantly increase emissions of air pollutants from the power generators, Cominco was required to apply for a new PSD permit. Cominco submitted its application in June 1998. As amended in 1999, Cominco's application sought permission to build a new generator to add to the 6 existing ones. Cominco argued that petitioners should determine that the best available control technology for that generator is a technology known as low NOx. Okay, that's actually pretty well written, which is not surprising because it's from a governmental agency and it's before the U.S. Supreme Court. I want to contrast that with the brief for the petitioner, the State of Alaska Department of Environmental Conservation. For generations, Eskimos hunting and fishing in the DeLong Mountains in northwest Alaska had been aware of orange and red-stained creek beds in which fish could not survive. In the 1960s, a bush pilot and part-time prospector by the name of Bob Baker noticed striking discolorations in the hills and creek beds of a wide valley in the western DeLongs. Unable to land his plane on the rocky tundra to investigate, Baker alerted the U.S. Geological Survey. Exploration of the area eventually led to the discovery of a wealth of zinc and lead deposits. Although Baker died before the significance of his observations became known, his faithful traveling companion, an Irish setter who often flew shotgun, was immortalized by a geologist who dubbed the creek Baker had spotted Red Dog Creek. The Red Dog Mine, now the world's largest source of zinc concentrate, is located about 100 miles north of the Arctic Circle. The remote and sparsely populated area is one of the harshest and most inaccessible regions on Earth. No roads connect its 11 communities to each other or the outside world. From late May, when the ice on the river breaks, until October, boats are the area's main mode of transportation. In the winter, temperatures can drop to nearly 90 degrees below zero, and the region is enveloped in darkness both night and day. Operating 365 days a year, 24 hours a day, the Red Dog Mine is the largest private employer in the Northwest Arctic Borough, an area roughly the size of the state of Indiana with a population of about 7,000. The vast majority of the area's residents are Eskimos whose ancestors have inhabited the region for thousands of years. The region offers only limited year-round employment opportunities, particularly in the private sector. In the 2 years preceding Alaska's permit decision, the borough's unemployment rate was the highest in the state. So I think you can see a bit of a contrast here, and I was actually first turned on to this case by a former graduate of Texas Tech, a guy named C.J. Baker, one of our great graduates, in a conversation we had about legal writing and appellate advocacy. And I went and read this and really learned the lesson that you can often learn more from young attorneys and students than you end up teaching them. And I really liked the petitioner's brief more, and the reason I liked it more is because it tells a story. When I read it, just as Elizabeth discussed Don Willett's concurrence, you really envision what is happening, okay? And I think this served as a good contrast about legal storytelling. Now I have a question for you. Does anyone know who wrote the petitioner brief in this case? Chief Justice John Roberts, when he was in private practice, actually wrote the brief for petitioner. In fact, John Roberts is someone I've often said is probably the most talented legal writer in the United States, both in his writing in private practice and in his opinions. In fact, there's also a blog post by the Legal Writing Pro about John Roberts' brief here, so I'd refer you to that for further consideration. So, here's the problem we have in legal writing. We'll often tell our young attorneys or often teach our students, when you write the facts of your case, you need to tell your client's story. And the problem is we don't know really how to describe it past that simple statement. It's something I struggled with in teaching legal writing. It's something I had to put a great deal of thought into. What are the mechanics of telling a story? We know how to say it, but it's easier said than done. And I think part of the problem is how we have our law school education. Here's an example. Whenever you're in any of your doctrinal law school classes, what is the question they always ask you first when you're called on? They say, Mr. So-and-so or Mrs. So-and-so, can you please recite the facts of the case? Okay? And of course, this is the famous or infamous hairy hand case we saw from the paper chase, Hawkins versus McGee. But what's the second question they always ask? I want to now talk about the court's analysis. They'll go immediately into that. Well, what's the problem that this presents? The problem is, as lawyers, the way we're trained with this notion that the facts are what they are. And the real interest in reading any legal opinion or studying any case is simply what is the court's reasoning and analysis as applied to those facts. When in reality, those of us who practice appellate law, especially when you lose a case and you read that court's opinion, how often do you actually agree with the court's recitation of the facts? In other words, if you're knowledgeable about the case, it's very often the case that you think, that's not really what happened at all. Of course, that's what opposing counsel said happened, but it only ended up in this final form after a great deal of struggle and battle throughout all stages of the process. And this is what some scholars have referred to as factual indeterminacy, which is this notion that facts are not something that are readily available. It's not something that we can just reach out and know. And when they end up in a legal opinion, that doesn't actually mean that that's what happened in the case. And it's important that we recognize that on the front end because we need to be fighting this battle of persuasion the entire time. And we need to pay more attention to how we tell the story of our case and how we present our client to the judge, to the jury, to the appellate panel in such a way that suggests the resolution that we're seeking. And this is the biggest takeaway here, is that the facts are a battleground of persuasion that begins with the pleadings of the case, the complaint, the answer. It goes through pretrial motions, trial motions, and appellate briefing all the way to the Supreme Court. And you can see that if we look back at these two sections I read at the beginning, John Roberts' brief, he's still telling the story even to the Supreme Court. And perhaps that's a story that's been told 3 or 4 times by that point. but it's still incredibly important, and we need to recognize this. So, the question arises, how do we start to think about telling a story? Well, the first place to start is perhaps a psychological question. What is going to motivate our reader? In this case, of course, our reader is the judge, jury, appellate panel, all the way up through an en banc panel or Supreme Court. Well, obviously, they're going to be motivated and influenced, perhaps primarily, by our legal reasoning. But very, very important, and if not equally important, are the story of the case. Because when you talk to judges, and I've had the opportunity to do so on several occasions, they'll often tell you that what we do in our job is we just want to get the case right. We want to have an outcome that's fair. Even though, you read the reasoning, sometimes it hardly seems equitable. That at least is their psychological position that they start with. So in our facts section is where we can get at a lot of this psychological aspect of it. Notions of fairness, common sense, and compassion. So what's the simplest form of telling a story? I guess I should have started with Aristotle, who said that a story has to have a beginning, a middle, and an end. And we'll come back to that in a sense. But another way of talking about it are, what are the main ingredients? Well, you want to have a character. You want that character to experience a conflict, and you want the conflict to be resolved. Okay? Now, if you read Cormac McCarthy, you don't always get the resolution that you want, but it's something we anticipate because it's part of the story we've always been told. Going all the way back to perhaps one of the first stories we hear from the Gospel of Mark. The story of Jesus of Nazareth has these exact same ingredients, and in fact, it's been studied by scholars as looking at these very types of components and how that story is presented or told to the reader. Now, we can map these things onto the legal realm by thinking of the character as our client. Okay, the conflict, well, that's the conflict. That's what disrupted the status quo, and we'll talk about that a little bit more. And then the resolution is really what we're asking the court to do. That's the relief we're seeking in this case. So let's keep in mind, in the back of our mind, the two primary goals that we're seeking to achieve throughout the process. We want the reader, the judge, the jury, the panel, to care about the character, in other words, our client, throughout the conflict as they experience it and as we present it to them. Second, we want to make the resolution fit the character in the conflict. In other words, we want the relief we're seeking to be an appropriate remedy given the nature of our client and what they've been experiencing. So we need to be thinking about how we're presenting it in such a way that suggests that resolution. So let's take a closer look at these three things: character, conflict, and resolution. Any character that someone is going to care about has to have needs and goals, and those have to be expressed in some way. It doesn't have to be expressed explicitly to the reader, but it can be expressed through action, for example, or a description of action. We have to keep in mind that the conflict is the thing that prevents the character or our client from achieving their goals, from satisfying their needs. And ultimately, to keep in mind that for the reader, the judge, the jury, the panel, to relate to our character, they have to at least understand the needs and goals of our client. And if we're just saying, here's what happened, one thing after another, the reader is not experiencing this, and they're going to have a much more difficult time relating to our client, which is going to give the reader not nearly as much of an incentive to give the relief we're seeking. Okay, what do I mean when I say conflict? Well, we often think of conflict, or if you look at people who are in rhetoric departments in universities, and some legal writers have looked at this through a new field called applied legal storytelling. We think of conflict in terms of archetypes. These are kind of your classic conflict scenarios, and I've listed some of them here. So if we think back to the example that I presented at the beginning, dealing with this little company in Alaska in the middle of nowhere in the freezing weather, And all of a sudden you have the Environmental Protection Agency coming in from Washington trying to tell them what to do, which is perhaps exposing these 7,000 residents to losing their jobs. And what else is there to do in Alaska if you can't mine at the Red Dog Mine? What type of conflict do you think is being presented there by Judge Roberts or Justice Roberts? Well, I would think here it's person against institution or person against machine. Person can be broadly applied to a business, but we're talking about the David and Goliath archetype. The little guy trying to stand up to the big guy who's trying to interfere in the way the little guy wants to live their life. Okay? And I think that's very much what Roberts had in mind when he was writing that brief, is I want to present this in the smallest possible way, where we start with this man flying a plane with the dog riding shotgun, sees a creek bed and thinks to himself, perhaps there's something here. And this seed has grown a little bit, but not nearly big enough to cause any problems. Yet you have the EPA coming in trying to squash this dream. Okay? So that's the conflict. And think about how you frame your conflict. Personally, I represent a lot of unsympathetic clients at the Office of the Federal Public Defender. So I have to think more creatively. Maybe it's a person who's dealing drugs, involved in the drug trade, but they've succumbed to drug addiction. So maybe I want to present it as person against self. They're struggling with their own mistakes that they've made, their own bad decisions. Or perhaps I want to frame it as ideal against institution, where you have law enforcement overreach that's maybe threatening to violate the Fourth Amendment or the Fifth Amendment or the Sixth Amendment, depending on the circumstances. So sometimes you have to think somewhat creatively. So that's conflict. Let's also keep in mind that there's a close relationship between the character, that's your client, and then the conflict they're experiencing. And you want to describe the conflict in such a way that it brings out in the eyes of the reader the character, the depth of the character. How that character struggles reveals who they are. And a great source for this is looking at films, movies. Cool Hand Luke. For those of you that have seen Cool Hand Luke, how do we know what his inner character is? It's not because someone came and beat us over the head and told us he's this type of guy. It's because when he has a boxing match and he's greatly overpowered by someone who's much larger and stronger and more skilled, Cool Hand Luke's the guy that can get knocked down 100 times and keeps getting up. He's also the guy that can have, and this is where you get the title, be playing a game of cards and has no hand at all, but will go all in and force the other guy to call his bluff. So this is how we get a sense of a person's character, and this really does apply to legal writing. Let's also keep in mind that there's often more than one level of conflict, so we want to think deeply about this. There's millions of examples of this. The examples I put here in the movie Rocky, is it really about the boxing match? Or in the movie Platoon, is it really about the Vietnam War? So we're going to think about it more deeply if we can. So let's get to the resolution. In narrative terms, we're asking the judge, the jury, or the appellate panel to write the last chapter of the story for us, to give us the resolution, to give us the relief we're seeking, because we've already led them down the path, telling them about the character, telling about the conflict, and suggesting the appropriate resolution that can resolve that conflict in a way that's consistent with the character. Okay? And we want to present it in that way. Of course, this is a picture of Judge Dennis at the Fifth Circuit, who's my favorite judge to argue in front of. He always gives us a fair shake and is always very willing, if we have the right case and it warrants it, to give us the relief that we think is appropriate. And I think he's very fair in doing so. So let's talk about organization. I mentioned Aristotle before, beginning, middle, and end. Well, there's more recent scholars that have talked about it a little bit differently, and I really like this way of thinking about it. It's order, disorder, reorder. And that's a great way of thinking about something and framing it. So think about this. Think about this in one of your cases. You have the status quo. That happens before your case, where your client is trying to go about their business unmolested. And then something has interfered with the status quo, causing disorder. Whether it's someone has been arrested, someone has had their business infringed upon or interfered with, someone has had their contract breached. And that's created disorder. And what you're asking the court to do is come back and create reorder. That can be something entirely new from the original order, or it can be a return to the status quo. Thematically, of course, we want to end with something that suggests the resolution. And you want to write it in such a way that the judge that's reading it, or the justice, if you make it all the way to the Supreme Court, is kind of nodding to themselves because they've been walking along this path with you. And by the time you say, this is what we want you to do in this case, they're already there with you. They already anticipated what you're going to ask for, and they already agree with you in a sense. Now, of course, if your petitioner or respondent's going to have their chance to muddy the waters a bit, but at least when they're reading your document the first time, this is where you would like to be. Okay? I want to give a couple examples that I've written to kind of create a contrast here. And it's just a scenario where a person is approached by law enforcement. So this is how I would write it as a criminal defense attorney and trying to apply some of these techniques. During the morning of May 22nd, 2017, Brandon Beck, a federal public defender, was walking from a parking lot to the Texas Tech University School of Law to teach a CLE as he was approached by two officers, as I often am. The officers approached briskly, held out their hands to signal Mr. Beck to stop, and displayed their badges. Mr. Beck identified himself, explained where he was going and where he was coming from, and asked if he could be on his way. Unsatisfied by his explanation, one of the officers grabbed Mr. Beck's briefcase out of his hand, while the other officer informed him that he would have to remain on the sidewalk for questioning. Mr. Beck remained polite and complied with the officer's every request except when they demanded consent to search his briefcase. The duration of his seizure was approximately 1.5 hours, and the average temperature during that time was 90 degrees Fahrenheit. Both officers testified at the suppression hearing that Mr. Beck was not free to leave at any point during the encounter. Okay, Fourth Amendment implications. At the end of his seizure, despite Mr. Beck's unwavering refusal of a search, the officer searched his briefcase and found a personal use amount of marijuana within an inside zipper pocket. This is how I write it. Now the prosecutor's office is going to have an opportunity to write their version. We have a couple of appellate prosecutors, and they would write it better than the way I wrote it, I assure you. On the morning of May 22nd, 2017, of course, we're from the officer's perspective now. Officers Smith and Jones were conducting a routine patrol near downtown Lubbock. They observed a young man, thank you very much, carrying a large briefcase, walking through a parking lot in the direction of the Texas Tech University School of Law. Based on the officer's training and experience, this young man appeared suspicious because he was wearing slacks and a sport coat on a warm day, and the briefcase appeared heavy, as if it were full of narcotics rather than a laptop or papers. The officers will testify to this, by the way, that my briefcase is consistent with narcotics trafficking. We see it all the time. Additionally, the officers observed the man walking quickly and looking around as he walked, which is consistent with narcotics trafficking. The officers also saw a bead of sweat forming on the man's forehead, which is a symptom of extreme nervousness. Based on these observations, the officers conducted a routine consensual stop of the man. The man was immediately defensive, refusing a request to search his briefcase. Based on the officer's training and experience, defensiveness and a refusal to consent to search is consistent with criminal activity. Ultimately, the officers' suspicions were vindicated when they searched the suspect's briefcase and recovered a significant amount of illegal narcotics inside a hidden compartment. And I'll tell you, if I lose this case and the appellate opinion is issued, say by the Fifth Circuit, it will read like this. Okay? If I win the case before the Court of Appeals in the Ninth Circuit, It will read like this, okay? Now, perhaps neither of these is exactly what everyone would agree what happened, but the battle has been fought for a long time, and to the victor go the spoils. And I want to leave you with one last thought on places where you can see excellent aspects of nonfiction storytelling. Essay writers, George Orwell has written some incredible nonfiction essays that really demonstrate some of these principles. Long-form articles, which are becoming much more popular, that employ great examples of nonfiction storytelling. And also documentary filmmaking. Look at how these filmmakers have taken nonfiction source material and edit it together in such a way that it tells a compelling story. So think about that when you're looking at anything like this in the future. And if you guys have any questions or feedback, this is how you can reach me. And does anyone have a question here today?
Brandon, when we're trying to write or teach someone to write a fact statement, has to be accurate, has to be truthful, all those kinds of things, because it's a legal document. How do we teach telling the story accurately but persuasively?
That's right.
The difficulty that students always have is that they want to throw in all these modifiers that are not appropriate for the story they're trying to tell.
That's absolutely right. And what you have to do is look at examples of how it's done well, first and foremost. So I've given you an example of this brief. Some of these examples here are them done well. But there is a danger, right? You can never be dishonest. That's number one. You can be persuasive but never dishonest. And they want to make it over dramatic at first. They want to make it over sentimental at first. We're not talking about it was a dark and stormy night. We're not talking about the police officer taking a copy of the Fourth Amendment and putting it through the shredder before our own eyes. That's not what we're talking about. We're talking about a much more subtle, nuanced approach that can be extremely effective if done well, but there is a danger of going overboard with it, and we have to always guard against that. And I wanted to give some examples, but we're not going to have time, of it being way over dramatized or overly sentimental. And that's not what I'm advocating for at all. So it's difficult to teach, and that's the problem. So any other questions? Thank you very much.
Thank you, Brandon. One of the things that I started a few years ago in my own class was taking Tennessee versus Payne, where you have like 72 stab wounds, and the Supreme Court obviously adopted the state's version of the facts, right? And I have the students rewrite it from the defendant's perspective, and still have, like you said, being honest, but yet let's diminish the impact of this and see what they can do with it. So anyway, thank you so much for being here. Let me remind you, if you are not a member of the appellate section of the bar and you would like to be, there is a handout right there that gives you some information about some of the benefits of joining and how to join, and would love for you to pick up one of those. Also, if you came in later, there is an attendance sheet running around. Thank you, Mr. Burkhart. In the very back, please go ahead and record your attendance so we can give you some CLE credit. And then I'm going to do a plug. One more thing. I've got a request for you. I do teach legal practice with some of my colleagues here, and we have an appellate brief contest at the end of the year, and we are always seeking judges to help us find the best of our students' appellate briefs. So if you're interested in perhaps being an outside judge, we only load you down with about 6 or so. And all you have to do is just do a read through and see which ones are more persuasive to you. And so if you would be willing to do that, this is a great group, your appellate lawyers. I have my card there. If you would not mind picking one of those up and just shooting me an email and saying, hey, I wouldn't mind doing that. We give you some time. We don't need it until the beginning of the school year. So there's my little plug for you. Thank you so much for your attendance here. We appreciate you being here. And thank you so much, Larry, Brandon, and Elizabeth, who had to run. We appreciate it.